It really is an honor for me to introduce the keynote speaker for today's conference. Professor Pina D'Agostino is a law professor, lawyer, public speaker, board director, and internationally recognized scholar at Osgoode Hall Law School at York University, specializing in copyright, intellectual property, emerging technologies, innovation, law, and policy. She joined Osgoode Hall in 2006 and is regularly called by Canadian and international governments for advice. I certainly have called her quite a few times. She has testified before the Canadian Parliament and is a widely published author. She regularly serves as a consultant and expert witness and is a cited authority at the Supreme Court of Canada and in various media. Professor D'Agostino serves as the editor-in-chief for the Intellectual Property Journal, and in 2022 was recognized as the top 25 most influential lawyers in Canada by Canadian Law Magazine, and top 5 in business law. She was also the recipient of the recently announced 2004 Ontario Minister of Colleges and Universities Awards for Excellence in Innovation and Entrepreneurship. Dr. D'Agostino is the overall director of the Connected Minds, Neural and Machine Systems for a Healthy, Just, and Society, and is also co-founder and co-director of the new Center for Artificial Intelligence and Society at York University. Today, Dr. D'Agostino will share valuable insights on the Canadian IP ecosystem, a subject that is both timely and critical as we navigate the role of IP as an economic driver. So please join me in welcoming Dr. D'Agostino.
Right. Merci, Constantinos. What an honor to be here. Merci tout le monde. Je suis vraiment heureuse d'être ici avec vous. I love being back in Ottawa, which is really a home for me. And I'm very grateful also to Paul at CIGI and his leadership with Constantinos and his incredible team. First rate. So I used to work here in Ottawa, and I see some of my colleagues still in the room, and now, of course, being at Osgoode, some of my students get to be here. So it's a true honor. And Ottawa really is a home. When my mom immigrated from Italy to Canada, she settled here in Ottawa. So half of my family is still here. So it's really a pleasure. And also want to talk about something that is really true and dear to my heart, really talking about IP. So what I want to do is in the next 30 minutes or so, depending on time, I'm happy to squeeze it up, is to really tell you 3 stories and bring them together. And in doing so, what I really want to emphasize is the importance of IP, the need to make it here, the need to keep it here in-house and commercialize it here and really hold it dear to our hearts. And ultimately, what we're always dealing with are the same issues, right? Issues of ownership, access, and control to works, now data, which really transcend each new technology. And tech keeps moving at a galloping pace. And it was really heartening to see in the Globe, the piece by Jim Balsillie talk about, data as a natural resource, and really that the algorithms are the new machines. So this is the new era. And if we go back to even our last presenters and talking about where Canada is leading and going forward, the new cutting edge technologies, that's where we need to get it right. So the first is a story about really my work in copyright and freelancers in publishing. And the second is a story about my work in e-health. And then the last is a story yet to be written. And that's, I think, the fun and inspiring part and where each of you in this room really matter. And I'd like to really shine the spotlight on Canada's IP innovation ecosystem and look forward, because we always need to look forward. So let's start at the beginning with my fascination for IP, because context and history is very important. And it feels that even now, with the galloping pace of tech, we need to think things up brand new. Well, not so much the case. Let's look at where we started historically. And for me, my history was the University of Oxford, where I started my doctoral work. Yes, Rutha. And it still looks a lot the same today, right? So when I was there, I started there in 2001. And I was really struggling to figure out what's that magic topic. And this is something that, I see my students struggle with. And I tell them all the time, really picking that magical topic is really, I think, 80% of the work. You really want to zero in on something that you're passionate about and that is close and dear to your heart. And that's what I advise my students, which for me, studying under the global leading light of Professor David Vaver, you want to make him proud, because he also gave me that advice. And so picture 2001 and all that is going on at the time in the world. And for me, was really my passion for good writing. There was a time where I actually thought I was going to be a journalist. I was incredibly entrenched in the student press, and I was working, deadline to deadline, and really thought this was going to be my career. But at the same time, in my core and DNA, I had the justice gene. So this is what my husband says, I have a justice gene, and now we see that in my kids who talk about fairness and all that, right? But for me, it was really about, my love for the law as a vehicle of change and lifting up those underrepresented across various communities, right? So what happens when you bring in love for good writing and love for the law as a vehicle of change to lift up underrepresented communities? Well, it's obvious. That's copyright law. So for me, I wanted to look at copyright law because copyright law is that vehicle to protect literary works, and especially their authors, right? Who live contract to contract, oftentimes if they're independent contractors, to earn a living through their works. So that's what I was going to study. And now recall that it's 2001. And it was the explosion of that big, bold new technology called the internet. So I was in the middle of it all, and I was seeing a flurry of writings going on, and some cases that have started percolating across the courts. And I'm thinking, one that really resonated with me was Jonathan Tassini suing the New York Times, right? In the New York Times, we see that now back in the courts. But then it was the New York Times getting sued. At the same time, and this is when actually I was working here in Ottawa, I remember being at PCH and walking down the street and going to the Supreme Court at the very hearing of Heather Robertson suing the Globe and Mail, our class action. So what I decided was I wanted to look at these issues because it meant that these authors are struggling and it didn't sit right with me. So I wanted to really make this the object of my study. Now let's fast forward about 2 decades, right? And we've come full circle in many ways, as it's not just the publishers now. There's a bigger Pac-Man in town, right? And that Pac-Man is generative AI. And it's digesting and gobbling up lots of works. And by extension, not only publishers now, but freelance authors' works. And the stakes are that much higher. So publishers, and many now across the creative industries, have been caught by storm yet again, right? With this bigger, bolder, and shinier technology that is artificial intelligence. And more often than not, what I've observed is that the weaker party gets shortchanged. So history does repeat itself. And throughout my work in this area, I've argued that whenever you see a new technology and you see it adopted, commercialized, there's disruptions in the market. And there are renewed challenges to the existing structures. And what you see is that the weaker parties get shortchanged. And so I'm thinking here within the publishing industry, you see with the onset of the printing press, the CD-ROM, the internet, now generative AI, every time there's a new tech, there's a bubbling up of technology and the markets realign. And what you see is that often creators' interests get sidelined and forced into the background. And we've observed this throughout history. So the underlying issues are always fundamental questions of ownership, access, and control to works, or in today's speak, is really content, right, or data. And technology keeps moving at this galloping pace and faster and faster. And, we're talking about AI now, but of course, a few years from now, maybe even shorter, there's going to be a new technology. And again, a flurry of more activity and unknowns. And really, IP and copyright law seems to be the natural home now of these natural resources, the data, and always vying to catch up and always struggling to stay ahead. And we still see, and this is problematic, that the weaker parties get shortchanged. And so we'll continue to need to meet Konstantinos in conferences such as these to talk about these issues. So just to set the context, and this was, the book that I published after my doctoral work, and I'm still tracking this work. It's really useful to go back and shine the spotlight on freelance authors, right, and share their story, which is one that I've tracked over, the last decades, and not lose sight of their struggle, which is still relevant today, because we keep repeating the same mistakes, right? And so in terms of the publishing industry, and specifically in relation to what I looked at, which was periodical publishers of mainstream newspapers and magazines, what happened in the mid to late 1990s was that they started publishing freelance authors' works not only in print, but through a host of different media. And, selling these works to third-party databases. And there were a series of cases litigated. I mentioned, the US one, there was a Canadian one, and of course, a sprinkling across the globe in continental Europe, another jurisdiction which I looked at. And there were at least two arguments that were made. On the one hand, you had freelancers that argued that they didn't get any notice, they didn't give their consent, and they're not getting any monies for these additional uses of their works. On the other hand, publishers argued that, hey, there's nothing wrong here. There is no difference between the media. What we could have done in print, we can now do in these new media, right? And as I'm saying this, I hope you're thinking about like the current space we're in, right? And the arguments that are being made. They also argued that, okay, let's say there is copyright infringement. Well, we're allowed to do this because of the contracts that we have in place, these implied licenses, so that exonerates us. And even if that's not the case, authors, even if we don't, if we're not able to use your works, well, and we need to compensate you, let's take a wait and see approach. The tech is moving fast. We need to figure out the markets, our business models, and then we'll figure out what, if anything, we're going to give you. So these were arguments that were very much alive, and I digested them all myself, no ChatGPT needed, in my own writings and, in this book. So the central issue for me was really one of copyright contract, was not so much getting nitpicky, inputs, outputs, now looking at the differences between the media, but what were the fundamental questions of ownership, access, and control, the relationship between the parties, between the authors and the publishers, right? And it was an ownership question. Yes, ownership is important. And here in North America, of course, there is, in the US, the works made for hire doctrine. Here we have during course of employment doctrine. And this is really relevant to freelancers, right? Who are independent contractors for the purposes of the law, unless, of course, there's an agreement stating otherwise. So at issue, really, and why things get tricky is that we were dealing with a period where there were no written contracts in place. There were largely handshake deals between the parties, where only key terms like, publication date and word count were agreed upon. There was no mention on the, what's the electronics rights clause or all these other clauses that exist today. None of that was the case. So that made things tricky. Now, why should we care? Well, as I argued back then, and I hope you see the relevance of those arguments that are very much bubbling up now in the courts, is that the arguments are still germane today. So when you look at copyright policy and what is a copyright policy meant to do? Well, we like to say that it's meant to balance a diverse palette of interests. In this context, you have the authors, the publishers, and the users. Well, what you saw at least with the internet, is that these, copyright policies undermined, because ultimately you also get, where authors go unrewarded, and you get less diversity and access to works. I'm thinking, for instance, what the New York Times did when, the ruling was made against it, is that it's purged the freelance authors that didn't toe the line. So these are fundamental questions that we keep having to address. And this can't be in the public interest, which we very much care about here for Canada. Second, also freelancers are a vulnerable group, and I love the OECD, and it's so nice that you're here, Hélène. OECD statistics point to the rise of independent contractors as a labor law category. There's the gig economy. More and more workers are off the payroll because it's getting pricey. It's very expensive. It's cheaper to have workers be on piecework, right? So there's going to be more and more of these workers, and we need to confront these issues. And this is important for, yes, economic growth. What do we do with independent contractors? And third, it's a persisting problem, one that will not go away anytime soon. I mentioned, some of the technologies. Every time there's a new tech, there are going to be new challenges to the existing models, disruptors in the markets, in the economy, into the legal space, and we need to get it right. So even across the creative communities in the film industry, I'm thinking of when silent picture films became talkies in the 1920s. If you look it up, there was a bubbling of litigation. Every time there's a new technology, there's litigation. This also causes access to justice issues because we can't all afford to go to court. So last, also the wider socio and political economic context is implicated. So the issue is not just one that is limited, I mentioned the publishing industry, it's not just the cultural industry, but it's one that affects all industries, because when we're dealing with issues of ownership, access, and control to works, even the health sectors, even the medical community, and that'll be my second story. But what I'd like to share with you is that my own methodology was really going into the libraries. I went into the Bodleian Law Library in Oxford and uncovered many old cases. So I looked at the issue historically, philosophically, comparatively, looked at various jurisdictions internationally, and I, found in conclusion that the copyright treatment of this issue wasn't adequate, right? We weren't getting it right. Quelle surprise, eh? But that wasn't always the case, because in predecessor copyright statutes, we had more robust provisions in place to govern these issues. Over time, these have been diluted, slowly diluted in our laws. Things have become more laissez-faire, at least with respect to this issue. So given the imbalanced bargaining between these parties, and I also looked at some economic literature, the informational asymmetry between the parties, given these asymmetries between the parties, there was a need for intervention. And of course, we need to start with the government. And I made a whole slew of, different solutions to level the playing field, because that's really what we want, right? To lift up those underrepresented through our social and legal tools. Let's fast forward now to 2024. And what's fascinating is that publishers now are reorganizing their business models in real time. So I mentioned the bigger Pac-Man, right? Generative AI, and it's really all based on it ingesting as much content as possible. And recall that we've seen this movie before, right? Now it's all in the computer code speak of inputs and outputs, and for sure lining up all the differences between the media and trying to figure out where, copyright infringement lies. And really our nomenclature, even the way we speak about these issues is changing, right? So I find it fascinating now because publishers are using the very arguments that were used against them, against the big tech companies. So the same arguments repeat themselves. And in a sense, the question that I ask is, where are the weaker parties, the independent contractors, the freelancers in all of this? So you see that there are evolving business models, and this is just, OpenAI shaking hands with all these outfits. And so where are the freelancers in this? Well, if you see some, writings on this already, you see that they're really not getting their fair share. And the terms of these deals are not being disclosed. So we don't know who exactly is profiting. But if you talk to the authors, they're not happy. So you see that when they're busy negotiating, and then when negotiations fail, you end up in the courts. And I was waiting for this case. I thought, having studied this, I thought, when is the New York Times going to sue OpenAI, right? And sure enough, by the end of the year, it happened, December 27. And really, the issues are the same ones we saw back then, decades before, up again before the courts. And now, of course, we talked more earlier in terms of the outputs, right? The generative assisted, but it's also like the inputs. So inputs and outputs, to use today's speak, and really this is going to determine, many important issues of ownership, access, and control to works. And so we need to get this right. And so just before I get to my second story, there's, every day there's a new case before the courts. There's 27 now. I don't know if anyone has a different number. 27 before the U.S. courts on generative AI. Canada is going to see it very soon, probably by the end of the year that it's coming here. So how do we equip the judiciary now to tackle these issues, right? Because we're going to face the same tsunami that we saw back then, and it's coming. All the while, there's a flurry of writings. On AI, any day you go to a conference anywhere. Whereas our social media feeds are on overdrive. These issues are being discussed, and we need to figure out solutions. Also the World Intellectual Property Organization, I participated with a team. We put together that IP innovation toolkit. So we're looking at these issues, and yet, I fear that we keep watching the same movies with, endings that are not too happy. So let's go to a connected area, right, on e-health, where, in a sense, there's still fundamental questions of ownership, access, and control to works. And these are connected areas. Similar to the previous story with freelancers, there's freelancers also in e-health. They're independent contractors that are working, researchers that are working, healthcare professionals, and depending on their context and their status, there are ownership, access, and control issues. And here we're talking about, bigger stakes because there are often issues of life and death. So this is St. Peter's College, where I was in Oxford. And this is really an incredible team. And, we talk about interdisciplinary work, but in a way, this was early 2000s. And maybe the work that I did there was ahead of its time. Because when I talked about IP and data together, I literally had eyes rolling in the room. I never forget one time I wanted to just burrow myself in and just like, why am I here? There was an alternate voice going on. Because I felt back then, 20 years ago, the audience was not prepared to use those terms together, right? Data and IP. It was all about privacy, cyber, but you're talking about ownership issues and data. So it was actually a very unpleasant experience for me, to the point that I was like driven out of talking about it, because it's just, you don't feel good. And let's face it, we need to have fun too in our jobs. And it wasn't fun for me. Okay. So I've kind of now resurrected some of that work, because this was, I think, work ahead of its time on this team with, again, Professor David Waver was like the head PI of this. We got a grant from the ESRC to look at intellectual property rights and medical databases for a grid environment. And this was also pre-AI. We cared about looking at the IP issues and data because we wanted to make sure that there was a robust and solid structure for the governance of data. Guess what we're talking about now? This was, long time ago. So, the work had to be interdisciplinary. You can't just have the lawyers in the room, right? We needed the data there. So we had, the social scientists, computer scientists. We worked together to study one particular grid structure, and that was E-Diamond. So E-Diamond was also ahead of its time. The goals of E-Diamond, funded by the UK government, to the tune of, at the time, £4.25 million. It was a database that was meant to really eradicate, the lofty goals were to eradicate breast cancer. But to start by amassing mammogram data, to start to study it, analyze it, figure out better ways to treat breast cancer patients, and ultimately try and get ahead of it. So what happened, Tony Blair even made a statement saying like, this is incredible technology. We need this. So E-Diamond. So what we did was conduct an ethnographic study of E-Diamond. And we figured out, unfortunately, that the rights were stultified. So the parties did not turn their attention to, guess what? The IP issues. There was no ownership issues. The only party that actually had it right was IBM. IBM gave itself rights in perpetuity to own the data, to train its algorithms. So IBM was the only party with, the privilege of having lawyers at its behest to figure it out. The others, so in the purple, you see those are, the hospitals feeding the data to the universities, and you have all of these complexities. In some cases, we found that there was a nurse that actually owned the data if you applied existing laws. So, copyright is a challenging tool when you try and apply it. But at the time, you have all of these complexities, right? Patient walks in, we track what happens to it. The nurse writes up a report, and that gets uploaded onto the grid database. So all of these complexities. And now with AI, so that was a pre-AI. With AI, the goal was for that grid structure to be hooked up to many others, right? And that brings in more complexities now. And, live before us are generative AI issues. So now I'll leave you with the story to be written. And let's look at Canada's IP innovation ecosystem. I gave 2 examples already, right? Publishing, cultural industries, health. It's a rise of intangible assets. Rise in global patenting. We're getting smart globally. We're all patenting a little more. Now, when you look at Canada, we're relatively flat on this. And our applications, so while we're all the way inventing, we're not filing as much, right? There are not as many patents. And I just want to underscore, like, the data is really good up to 2021. Then, of course, because of the 18-month rule and the examination period, so that's still settling itself. But from 2005 to 2021, you see a slow decline. Also, when you look at ownership issues and assignees, in the Canadian, with the Canadian flag, largely, right, Canadian outfits, but 6 out of 10 assignees are taking their patents outside to they're foreign owned. And this is from PatSnap. So Access did October 10 last time. I asked, does history repeat itself? I testified before Parliament here. There's a report of the Standing Committee on Science and Research. We all know the case of insulin, right? And I won't go through that. A more recent case, perhaps, to talk about is the cardiac pacemaker, where we had Hobbes, who was an electrical engineer, thought, this is amazing, but I guess I'm not going to patent it. So it was, this photo in the Research Council of Canada archives, you see that it's a big device. Well, our friends south of us figured out a way to make it smaller. But going back to also the previous presenter and seeing the genesis of things, it started here with Hobbes, our Canadian inventor. Now, looking ahead to other sectors and, automotive, I have to say something about the automotive sector. I also sit on the board of the Ontario Centre of Innovation, OVIN. It's incredible what's happening in Ontario in the automotive space. $50 billion in investments are coming into Ontario. We had Project Arrow. There's going to be Project Arrow 2.0 luminaries in this sector, all looking to Canada. But if you look at the patents, relatively slight on activity. AI, another bubbling sector. And, this is cutting edge technology, as we heard from previous presenter. And dear Elias, thank you for this beautiful work, right, with Sean Martineau and Mazahir. You see where the China and US really going up in the heights, and Canada's somewhat flatlined in our activity. Then when we translate that to ownership, you see the same story where we're not owning the stuff that we even do file, we're then taking it out. And this is problematic, right? Because we don't want history to repeat itself. And so it irks me when I even have to write papers like this back in 2012 that, IP is good, IP is bad for innovation. No, neither are true. It's actually unsalutary to put these absolutist ways of talking about IP because it's much more complex than that, and we know that, and this audience knows that. So I've always been a fan of being, more sector-specific, more granular in our understanding of the issues. And so always a fan of strategic use of IP. So IP is not only patents. I talked about the copyrights, and of course, there's trade secrets came up. There's a whole bunch of others, and the need for ongoing education. So there is no one size fits all, and it depends really on the tech and what sectors we're talking about, and being very strategic. So that's where I get to be strategic with my own startup. So I literally rolled up my sleeves because I saw there was a need, and we talked about innovation, entrepreneurship and tech transfer. And I saw within the universities a need to have talent and to have the lawyers in the room. And so looking at Jim, you're going to be hearing from him soon. I'm so grateful to his leadership in this space. So Own Innovation, the Smart and Bigger, Norton Rose, and these are lawyers, law firms that work directly with our students to file those patents, right? And eventually get those building blocks for the commercialization of IP. And so far, we crunched the numbers and we've undercut over $2 million because we know it's expensive, right? And so this is my way of trying to undercut these costs in the law school, where it's a win-win because we're also future-proofing our students and future-proofing them for, the world of AI as well. There are success stories, and very proud of these. You may know Skygauge Robotics, Indigenous Friends, IntelliJoint, Neural. We filed their first patents, we helped them out. And they say, you will hear them on panels, they will repeatedly say, but for the IP Innovation Clinic, they would not exist. These are Canadian success stories, and they're still in Canada. Oh, okay. I'll just go back to the chatbot, and I'm really grateful to the National IP Clinics program, which gave us incredible funding for a chatbot that we started before ChatGPT. But because we wanted to do things the legal way, it's taking us a bit longer, right? So this is something that is really also close to my heart. And always as an educator and an academic, I keep innovating in my own space. And so bringing the world of, machine learning and AI in making things more efficient also for our inventors. And this is my last project. Well, there's many projects, but the last that I'll talk with you about today, which Konstantinos mentioned, Connected Minds. Very grateful to the leadership of the Canadian government here, the Canada First Research Excellence Fund. And every about 7 years, the federal government really infuses money into key universities to advance the cutting edge research. So York University was very lucky. So I was one of the PIs on this, and we brought in $318 million, the historic grant at York University in partnership with Queen's University, where we're looking at the increasing intermingling between humans and machines. And one day, very soon, machines and machines, right? And really trying to get ahead. And there's a sense of urgency in terms of understanding. We're still, from a neuro perspective, trying to understand the science of the brain and the brain of the machines. So it's that intermingling and ultimately advancing socially responsible technology for the benefit of Canada is what we're looking at. And I can assure you, as the lawyer, the IP lawyer in the room, now the scientific director, so I'm the head of this fund, I am raising the IP flag. And it will be my goal to keep it in-house, commercialize it, and see many success stories come from this. So with that, merci tout le monde, and I just look forward to continuing the conversation. And again, big thanks to Konstantinos and Paul for their leadership in bringing us together.
Great. All right. Thank you very much, Pina, for a wonderful presentation. Maybe you could join me here on the comfy chairs. Maybe we have a couple of minutes for some questions. And while we wait for people to formulate questions, let me start off. So you've always been at the forefront. You're really ahead of your time in so many of these areas. And it's looking at what you did on e-health, linking IP and data at the forefront. Getting back to something you said right at the beginning of your presentation, weaker parties get shortchanged when there are new technologies coming on board. And you spoke about the weaker parties being at the individual level. Maybe you can opine on this. How does that scale up to a national level? In particular, when we're talking about data, access to data, controlled data. Can you perhaps comment on that?
Yeah, for sure. So the smaller parties now in the generative AI landscape tend to be, well, and I think this came up, the SMEs, right? The smaller players that are trying to innovate and use the data. Of course, the larger parties that are able to capture more of it are the big tech companies, right? So there you see an imbalance of power. And so when we develop policies, we need to be cognizant of these players. Because there is a lot of good still in big tech, if done in a way that is, I think, responsible, right? We talk about responsible AI. I'm thinking about, I gave a presentation I think it's about a month ago now at the IFRRO, and there's a copyright clearance center which says, in its tagline that responsible AI starts with licensing. So I feel that, and there's balance of power issues. And this is an age-old problem. So every time you have parties that are not on an equal level playing field, you need robust mechanisms in society to lift up and put them on an equal level. Because we want to ensure that there's a healthy, exchange between the smaller players to come up and also become like big tech. Because we want to have homegrown big tech. So you do need that to have the structures in place to enable that possibility. So that's where I would say, from the individual level, the actual independent contractors that even work in these places, to then at a corporate level, corporate governance, right? That's also important.
And thanks, Pina. And just maybe pushing it a bit further, scaling it up to a national level, because we're talking about Canadian productivity, Canadian innovation. How do you see that?
Yeah. Okay, then let's look outside of Canada, which we need to do. You see that Canada is a smaller player compared to now. Well, we saw some of the data, and it's been presented, some of the bigger countries. So there, internationally, we can get creative and think, if there is going to be some international mechanism in place, or when we think about trade, what tools and mechanisms can we develop and have on a global level, and even looking at countries that don't have access to intellectual property, and we have mandatory licensing schemes to really level the playing field, right? But at the same time, ensure that key parties get rewarded.
Great. Thanks so much. I do believe we have time for one question. We have a hand up in maybe.
So I actually, my question was very similar to what you've already said. So let's hand it off to the other person.
You were both in my direct line to say thank you, Andy, for.
Okay, thank you very much. Thank you very much for that presentation keynote. My question is regards to regulation of copyright and artificial intelligence. Now, Parliament may not move quick enough to give us specific legislation to say this is what it is. So we turn to the judiciary. So many cases are coming up. You mentioned the US. In Canada, I think there was one case, but they settled out of court. So my question is, when the judiciary hands down a decision and then Parliament later comes up with a legislation and there's a clash, do you think the disharmony would lead to an enrichment of the jurisprudence in that area, which is lacking at the moment? So I'm just trying to look at the interplay between these two institutions and how their relationship and communication can shape regulation of copyright in terms of impact on AI.
Yeah, no, I love that. Of course, we do need a richer jurisprudence here. And I'm a big believer in the courts to step in when necessary. But I'm also a believer in ensuring that parties have the tools to be able to even go to the courts. So I mentioned access to justice, and usually what you see is a disparity in, those who can actually afford to go to the courts and litigate. So that to me is a concern. So I would try and avoid, and I say this as a lawyer, like the courts is the last option, right? To go to the courts. I still believe in the power of these issues. We need to get it right in government, right? Our policies need to be mindful and anticipate these issues so that we don't end up in the courts. Of course, when we do, yes, but let's avoid it, and let's ensure that the laws are, in my view, stronger to look at these issues. So I would love, and again, I was speaking and eyes were rolling even then, and I've done like a whole chapter on beautiful legislative provisions we used to have in predecessor copyright statutes. And I'd love to see those come back, because if we had those, we wouldn't have these issues today.
All right. Well, let's take this opportunity, everyone, to thank Pina D'Agostino for a wonderful presentation, for being our keynote speaker. Thank you.